and then we'll start the meeting. I trust that everybody who wanted to join did join the session. So welcome. I'm looking forward to our session. And I really hope that our topic, copyright plagiarism, will be a very interesting topic, and it does apply to all of us in all different walks of life. I just want to hear, can someone just confirm, can you hear me clearly?
Yes, we can hear you, Matilda.
Thank you so much, Timby. Firstly, I want to know, is there any apologies for our meeting? Our secretary, Erna Mostert, did apologize. She has urgent matters that she needs to take care of today. Is there any other apologies? Okay, I take it as none. I am not going to run through the minutes. The members of the Free State LISLIG did receive the minutes, and I did see one or two mistakes. I will just speak to Erna about that. But what I want us to speak about is matters of the day, which is point 6. I would like to urge each and everybody, please speak to all your colleagues, friends, and co-workers to join either LIHASA or LISLIG, as we are a very small group, and it makes it difficult to continue as a group with such a low number of members. Luckily, we still have Zoom meetings, and that helps us to have nice meetings, even though we don't see face to face, but at least we can have nice meetings with very interesting topics, and we don't need to drive far to attend these meetings. The next point on the agenda is the elections. All Free State LISLIG members, please take note that later during the year, we assume around September, there will be an AGM. So please avail yourselves to be available for the committee when we make calls for that. And then everyone can listen to this, the national awards. I'm sure all of you did receive the emails from national office with regards to the Nevada LMS Emerging Librarian. Currently, Nambita from the Free State has that award. She was awarded it last year. Then we also have the UKS Library of the Year Award. There's also the LIHASA Sabinet Library Leader Award, and Betsy Eyster, also from the Free State, was awarded it last year. So please, colleagues, let's nominate our colleagues and make sure we have good nominees for these awards and that it can be awarded rightfully. I just want to confirm, is our speaker on the group already? Mpumi, are you there?
Yes, I'm here. I just don't know if I'm audible.
That's good to see you, Mpumi. Let me quickly introduce Mpumi to you. Mpumi, firstly, I want to say thank you so much for availing yourself on this topic. Nompumelelo Maleo is a copyright officer at the University of the Free State. She has been with the university since 2016. Ms. Malejo holds a postgraduate diploma in labor law and has completed courses in intellectual property and licensing fields. Her main responsibility is to ensure that your university remains compliant with copyright regulations as prescribed by copyright law. Passionate about offering the best service to the university community, she has won an award for Best Emerging Service. Ms. Malloy, we are really looking forward to this topic. As I know, it's a hot topic, and especially people at the universities with students that have to turn in the assignments need to be very attentive of this topic, and it will be very interesting to listen to you. So please take the floor and take us through your topic.
Okay, thank you. Thank you so much, Matilda. I'm not sure if you can hear me. You didn't confirm.
Sorry, yes, I can hear you clearly.
All right. Do I need to turn on my camera or we can proceed?
If you would like to, just turn it on for 1.
Hello?
Sorry, Malloy. We can't see your picture. Just turn off your camera again. It's no problem, but you can continue with your speech, please.
All right, great. Everybody can hear me now?
Yes, thank you.
All right, thank you so much for the invitation. I know with copyright and plagiarism, a small detail just goes and complicates everything. So today we're going to discuss copyright and plagiarism and the differences that lie between the two. So yeah, copyright and plagiarism, the difference between the two. Copyright is a form of intellectual property that protects an original expressed idea. So what that means is copyright law can only protect an idea that is expressed in any way of the options that exist. It can be on paper, it can be a recording, etc., but it must be already expressed. It can't be something, it can't protect something that is only in your mind or something that you only communicate verbally. So yes, that's what. Sorry. Okay. And then plagiarism, on the other hand, is the action of copying or duplicating an existing work belonging to someone else, and then you claim it as your own, or using a work and then failing to give the due credit to the creator of the original work. So that's where the differences lie. Copyright is an actual law that we must all follow, whether we like it or not, where plagiarism is more a moral or integrity. It's more ethics than law. So we have to both do both of them correctly, which is 1, follow the laws of copyright law, and 2, be ethical and not plagiarize. And then with plagiarism, we have 4 different types of plagiarism. So the first one is paraphrasing, which includes the action of paraphrasing somebody else's original work and then going on to put your name on it. Just because you go and change a few words here and there and the sentence construction, it does not necessarily now make the idea yours. All you've done is to simply go and just rework somebody else's work and then claim it as your own. So paraphrasing is
Sorry, Malloy, Can I just interrupt here? National Office, we cannot see the presentation. Can you please flight this slides for us? Sorry for the interruption.
No problem.
Can someone from National Office just respond to me, please? Vuyu, are you there?
Hello, Matilda. I am here, but I'm not the administrator, man.
Can I maybe try sharing my screen?
Yes, please go ahead.
I'm not sure if we can all see it now.
Yeah, we can see it.
Okay. Okay, good. Then the things I was talking about in the introduction was the differences between copyright and plagiarism. And then I was about to get into the 4 different types of plagiarisms that we have. Like I said, paraphrasing is one form where you go and just replace original words with synonyms and you restructure a sentence and then go back and claim it as your own. That's still does not exempt you from saying saying you haven't plagiarized. And then the second one is direct plagiarism. This is the action of going ahead and taking words as they are and then claiming it as your own. So let's say you have an assignment or you want to include an article, you go and you copy and paste in simple words, and then putting your name on it and not referencing the original author is direct plagiarism. And then the third one is the plagiarism of authorship. Let's say you go to a journal article and you purchase that journal article and then you come back and claim it as your own just because you've purchased it. So you would be committing a plagiarism of authorship in that situation. And then the fourth one is self-plagiarism, where one would recycle their own work and resubmit it for a new work. So just because the work belongs to you, it does not mean that you cannot, you can now go and use the same work for each and every project. So if you've used it once before, you must reference it. So if you have a book that discusses a separate one topic and you want to use it in another topic, you must reference yourself even. So with Turnitin, this tends to be a common problem mostly because the first round of submission, you'll find that you want to just test your similarity index. Maybe your university allows you to submit on Turnitin more than 3 times. So your first submission, you're just testing your similarity index, and it gives you a high percentage. Then you go back, you rework your assignment or your work, and you go back again to Turnitin to see if have you managed to reduce your similarity index, only to find that it's still high or it's picking up that you have now self-plagiarized, because applications like Turnitin will store your data the first time round. It does not know that you are just testing your similarity index. It also doesn't know the policy or the agreement you have with your lecturer or supervisor that you can submit many times. It just stores the data that you upload on it. So it can look like you are self-plagiarizing when you go back again to turn it in, which is why it's important that we have this human intervention when it comes to technologies like Turnitin, because once you explain to your lecturers are aware most of the time that this is a possibility and Turnitin, so they can see that this is the assignment you submitted before and you were just trying to reduce your Turnitin percentage. Now they can use their own discretion to decide whether you've went and self-plagiarized or not. Yeah, that's for academic purposes. It really helps to still have the human intervention to clear us from the accusation of self-plagiarism by apps such as Turnitin. And then self-plagiarism, it's a huge issue. It's an academic dishonesty. It's unethical. It's a scholarly misconduct. So yeah, it's not advisable for one to recycle their works without duly crediting themselves to say, just to motivate why they've decided to use their previous work in the current. And then ways of avoiding plagiarism. The first one is plagiarism, is paraphrasing. So I know that sounds a bit contradictory, but paraphrasing is a way of avoiding it as long as you reference correctly and you make sure that you follow all recommended referencing tools. So sorry about that. Paraphrasing and citing. Paraphrasing, as long as you cite, is a way of avoiding plagiarism. And then getting into copyright, like we said, it's a form of intellectual property and a law. Now with copyright, it doesn't require registration. As soon as you express your idea, you start to enjoy the benefits of copyright protection. One of the ways you can protect your works or recognize the protected work is through the copyright symbol. Even though the copyright symbol, it's not a requirement, I can still express my work and not put the copyright symbol, and it doesn't mean now I'm no longer copyright protected. It's not an actual requirement. However, it is advisable and recommended that one uses the symbol just to communicate to the user that this is a work that is copyright protected. And then the purpose of copyright law is to grant authors exclusive economic and moral rights for the works that they create. Economic rights, this is just to simply say that the author or the creator of the work can enjoy collection of royalties, let's say from Samro, Dalro, whatever, and they can continue to sell their works. It protects them for as long as the copyright period is there, that they can continue to enjoy the selling and reaping the benefits of collecting royalties from agencies such as Samro. And then with moral rights, this protects your works from being altered by somebody, by the user. So the user cannot go and alter your creation without seeking permission from you. If somebody's going to remix maybe a song from you, they need to follow the proper channels and ask for permission from you. And yeah, this moral right then also run for as long as the economic right exists. So it's for a period of 50 years in South Africa that one enjoys the protection of their works. And then the second purpose is to find a balance between the interests of creators, which is the above, and the public's access to content.
Can I
So-
interrupt you again, please? Someone is
Yes.
asking, can you please put the presentation in reading view, if you can?
Reading view.
Yes, please.
Okay. Okay, can you guide me on how do I do that?
Please press F5.
Okay, F5. I've pressed it.
All right, it's still not doing it.
Sorry, can I just come in here? If you go to the bottom of your PowerPoint, where your open screen, the one that you're busy with, right at the bottom, there are different screens. And on that screen, your one on your right-hand side will show you a big open screen. If you click on that it will open your whole PowerPoint.
At the bottom of my
At the bottom, yes.
Yes,
Where?
if you go down to the bottom, let me just get there. If you hover with your mouse right at the bottom, there you are.
Okay.
Okay, thanks.
All right. Okay. What was there?
Thanks.
Okay, so we were still discussing the purpose of copyright law. The second one is to just strike a balance between the two. Yes, fine. Is to strike a balance between the interests of the creator and giving access to the public to the content. So we give the author or the creator those exclusive rights. At the same time, we inform the public of how to use the works. So it's still accessible on condition that you follow the terms of use of the author. And then the third one is to promote responsible sharing of information and knowledge. Well, as universities, we are consumers of copyright, and we are also creators of copyright. So we wouldn't want somebody else infringing on our copyright and misusing our works. So we want naturally to respect somebody else's copyright. So the copyright law isn't designed to restrict anything really. It's just meant to promote responsible sharing of information. And then requirements of copyright protection in South Africa. The first one is that the author or creator must be a resident of South Africa, or they must be a member of the Berne Convention. Berne Convention is one of the leading ways, the world's biggest legal documentation of how we share copyrighted content amongst each other. The first requirement is that one must be a resident in this country. And then the second one is that the work must be in tangible form, as we've discussed. So if you have a song and you sing it in public and somebody else copies that song, they have not infringed on your copyright because you have not gone and recorded the song and put it in a CD, which is a tangible format, for it to enjoy copyright laws. So if you have an idea and you express it verbally, it does not enjoy the copyright laws. It must be in paper, a recording, a tangible format to say this is my work. It was created by me. Thirdly, it must be original. It cannot be a plagiarized work. The work that for it to enjoy the copyright protection laws, it must come from you, it must be original. And then the fourth one, is that it should not be immoral or go against public policy. So just because you are creating an original work, it can't be a work where you are breaking another law. For example, let's say you are creating a video, but your video is of child pornography, for instance. That's breaking the law on the other end. So there's no way that you get now to enjoy copyright protection on this side of the law. So it must still comply with all other public policies. And then how do you demonstrate that your work is copyright protected? We spoke about the copyright symbol. So that's what it will typically look like. If you open a book, you will see it. It's basically everywhere. Even our study guides, lecturers must put this symbol to show that this is content belonging to the university. So along with the copyright symbol is the date. So let's say you go and create or write a book and publish it today. So it will be copyright, and it will show it must show who the copyright belongs to. So your name or your publisher, or it must appear alongside that copyright symbol with the date, especially the year. So it will be copyright 2023. To show that as of 2023, for the next 50 years, this particular book belongs to Ms. Nompumelelo Maleu. So copyright is vested with me. If they need to get permission to use my works or they want to buy it from me, they must they must know that for the next 50 years, they need to comply with those rules, with those laws. And then another option is watermarking your work before you publish it. I know with social media, we just post things freely. But if you're an author or a creator, it is advisable that you watermark your work before you publish it, to show people, to showcase your work, to say, this is my artwork. This is what I can do for you if you would like to make use of my services. So it prevents somebody else from going and stealing your work that you've posted and saying that they've created the work. So watermarking it is also one of the quickest and best ways to claim your work. And then like we said, copyright law is not meant to restrict access to work. It's more to just give guideline on how to access to use copyright protected works. So how does one go about accessing copyrighted content? The first step to follow would be to determine whether permission is required. How do you do this? You want to see if the work is in the public domain. So works that are in the public domain, one, works such as legislation, case law, it could be copyright, work that is now out of copyright. It's been in the it's lost the 50-year period. It's run its 50 years period and no longer enjoys the protection. It automatically goes into the public domain. So you need to determine those two things. Was the work from 50 years back, or is it a legislation, or let's say with the health sector, for instance, our lecturers like to, well, get most of their information from Department of Health. This includes the images as well and figures that they use for their study guide. As long as it comes from there, then it is compliant. So it's okay. You don't need permission to use such works. And then the second way to determine if permission is required is through open access content. One would have to check whether the work they are using, the article, for instance, you want to use, or maybe even distribute. Is it open access content, and what are the terms of use are from the open access journal? Those things are usually communicated by the copyright owner. So you don't need to actually go and access permission. You can just check the terms of use as published by the journal and make sure that you follow them, and then you can enjoy or access that content. And then the third one is the Creative Commons licenses. There's 6 different types of Creative Commons licenses. One must familiarize themselves with the different types of licenses, where if you recognize one, then you know to follow the guidelines given by the Creative Commons license. It will tell you how to use the information and how to share the information. Like if it tells you to reference, then you do that. If it tells you not to sell the work, then you do that. You don't necessarily need to go and ask for permission for Creative Commons license works. And then the fourth thing to consider is the portion of the work used. With copyright protected works, we have guidelines by DALRO for academic purposes that tells us that we may only copy 10% or 1% or one chapter of a book, for instance. So the portion of work that you use is also something to consider. Is going beyond 10% now leads you to now be an infringer on copyright. So if you need to use beyond the recommended 10%, now you need to follow other channels in order to stay compliant. So there are also other things that determine the portion of work. Sometimes it's not possible to always follow the 10% recommendation, depending on the type of content you want to access. So for instance, you want to use a poem for educational purposes. You cannot copy only 10% of a poem. It's impossible. Then it defeats the purpose of why you're even trying to use the poem, because you need the poem as is. So there are works that need you to consider depending on the type of work you want to use. Portion is also worth considering. How much of this do I actually need to use, and in order to stay compliant? And then the second way of accessing copyright is to identify the owner of the copyright content. Once you've identified them, you need to contact them to see if you can request permission to use their works. This is in a situation where maybe the copyright owner does not necessarily have an agreement with DALRO, and they manage their own copyright. So you would then get permission from them, or they would charge you maybe a certain amount to say, okay, for X amount, you can use so much of my work and for so long. And then after that, you can remove, they will give instructions of how you can use their works. And then the fourth step to follow would be to get permission in writing. This could be through licenses, because sometimes you find that a copyright owner prefers to have a license, and that will just stipulate the terms of use, and they will give you instructions of how you should use their works, and you just have to follow the stipulations in the agreement in order to use the works. The issue of fair dealing. The 10% rule is also one of those fair use and fair dealing concepts. But there are 4 factors that determines what is fair and what isn't. So the first factor would be the purpose or the purpose and character of your use. So sometimes fair use will be, for instance, if you are not planning on distributing the work and you're using it for research purposes, for instance. So what is the purpose of your use of this content? Are you a researcher yourself, trying to critique a particular work? Then you have to use that work in order to critique it. So the purpose of your use is also something that determines whether or not your use is fair. The second one is the effect of the use upon the potential market. This means if you are using my works with the way that you are using it, will this affect my potential earning? If I was going to make an X amount from my works only being used by me and published by me, what does your use mean for my potential earning? So if it affects somebody else's potential market or potential reach to their audience, it's also something that could possibly contradict the fairness. Yeah, and then the second one, the third one is the amount of work or the portion of work that you use. Again, I refer to the 10% rule. It's a recommendation that we all follow. Depending on where you are, each country will have its own recommendations on what is fair and what is not. How much can you use of a work? For instance, if you're in China, where there's no copyright laws, you can use the whole thing. So they use everybody's works the way they want to, because they themselves don't have laws that restrict copyright. That's why you see that if Range Rover creates a Range Rover today, in China, there will be a Wing Rover the next day. It's because of the lack of those copyright laws. So depending on where you are, it is important to consider the amount or the portion of work that you use. And then the fourth factor is the nature of the work. Like I said, what is it that I'm trying to access? Is it a poem? Well, is it a journal article? Is it a book? The nature of the work. I can't use 10% of an art piece. I'd need to use the whole thing. So I need to follow the right channels in order to and follow all the other 3 factors and consider that in order for me to say, okay, it's okay for me, it's fair for me to use this artwork or this article because of whatever reason, but in following the other 3 factors. Okay, so the implications of infringement. With copyright, as I said, it is a law, and failure to follow the law or the regulations can result in the creator of the work can get an interdict to prevent potential infringement. Once they know that you intend to use their works, they can actually go and get an interdict to stop you from using their work. And now then you'll be legally obliged to not use their works until the owner allows you to. And then there's the issuing of fines, maybe if they discover that you have used the work and you've distributed it and you've now went against all the things that the law was meant to protect the creator from. So in South Africa, a minimum of 3,000 or 3 years imprisonment for infringement exists for the first offense. And if you are found to be doing it again for the second time, the maximum of 10,000 or 5 years of imprisonment is possible depending on what the courts decide. Whereas with plagiarism, each and every institution will have its own disciplinary measures in place. So once you find that a student is plagiarized, then there are disciplinary measures that could be followed according to that institution's policy. Okay, so the do's and don'ts of copyright and plagiarism are similar. So with the dues of copyright, you'd need to pay the quoted fee. You'd need to follow the terms of use from whatever Creative Commons license or whatever license agreement you went into with the author. Similarly with plagiarism, it's automatic, it's not advised, it's just automatic. You have to acknowledge the source in order to avoid plagiarism. That's just an automatic of avoiding plagiarism. And then you need to use the material as agreed. So if for instance, the Creative Commons license stops you from using the content for commercial purposes, then that's what you do. You follow those exact terms of use. And then and then indicate if any alterations have been made. Let's say you've been given permission to remix a song. You need to indicate that you've done so and let the author know, and they need to be okay with it. This, of course, is assuming that you've communicated when requesting permission what you'd like to do with the work. So if they grant you permission, even after that, you still need to say that this is the work and this is how I've remixed it, so that the author knows that the integrity of their work is not severely compromised. And then with the don'ts of it, with copyright, never ever use material that is copyright protected without permission. Secondly, the biggest problem is the reproduction and distribution for commercial purposes, because now you go and infringe on somebody else's economic right. So if you're going to sell, you need to speak to the copyright owner. Maybe you can reach an agreement and have some sort of something like a split sheet that says that the creator will get so much of per sale, for instance. So you cannot reproduce and distribute for commercial purposes without okaying it with the original author. And then the alteration of the work without permission. This is what you'll see resulting in most musicians being in court for copyright infringements, because you now went and remixed my work, or you've used my work without my permission. And you haven't followed the above two channels of okaying it with me and us going into an agreement. Now we have to go resolve it in court, which is an expensive exercise for both parties once an infringement occurs. So it's best to avoid doing the above without following the proper channels. And then the relevant legislation for library, archives, and museums comes from the sections inserted in the Copyright Amendment Bill. It's a very long list of amendments to the current copyright law. That one, if one is interested to find out what is on there, but it just basically it specifies what exempts libraries, archives, and museums from the current laws that exist. So if you are interested and want to maybe read and understand more, I'm happy to have a discussion, and we can go through any questions or ideas that one has about this. Yeah, and I think I'm almost done. Yeah, and then those are my references for where I got my information for today. Yeah, and I think that's the end of my story. Yeah.
Mpumi, thank you so very much. It was really a very interesting talk. I just want to hear from the participants. If you want to ask questions, please chip in and ask Mpumi questions. The first one I have here on chat is, when uploading slides for students on LMS, should it have a reference list at the end if I used a prescribed book? If you can please answer that, and if there's anyone else who want to ask a question, please feel free.
Okay. Okay, so if I'm understanding you correctly, you want to upload slides. Is the actual chapter in the part of what you want to upload? Is what I want to understand, or are you referencing to say, giving direction to students to say, you can access this source from this book and maybe say where it's available? Because if you go on the route of uploading a chapter, you must still follow clearance procedures, clear it with Dauro, and if Dauro doesn't have an agreement with the copyright owner, they will inform you, and then you'll follow the other channels of asking permission from the copyright owner, and then they'll hopefully respond and give you permission to use the work for educational purposes, of course. But all of that must be specified when requesting permission initially. So I'm not sure if I have answered, but yeah, those are the channels to follow. Otherwise, if let's say you are uploading, you want to upload a journal article, it's best, what we do at the University of the Free State is that we advise our academics to just place the link to the article as opposed to the actual article. This avoids the admin of having to go and request clearance from Dauro, and it keeps you in compliance. With things such as chapters, once you have gotten clearance from Dalro, then you only upload what they've given you permission to. And for if you'll be offering the module for a second semester, then they've cleared you to upload this specific chapter for the semester. Once it's done, you need to remove it. It's not a forever thing. So you need to renew the access with or clearance with Dalro each and every academic period for which you would like to use a copyrighted chapter, for instance.
I see there's a hand. Can you please proceed with your question?
Hey, I'm not sure if you can hear me. Can you hear me?
Yes, I can.
Okay, so thank you, Mpumi, for the wonderful presentation. Let me just start there. So my one question, I see somewhere in the chat, I think something popped up and somebody was clarifying that. You mentioned works of 50 years or more. So I don't know if you can just clarify there that, you know, one is able to use work that is 50 years or more, and, you know, what are the terms of that? That was my one question. And the second one is, as a museum, I work for a museum. As a museum, obviously we use a lot of work for research purposes. So, for example, when we cite an image used in a text, so if we properly referenced where we got the image from, that would essentially be acknowledging the source. So are you then you don't need to pursue getting copyright of the image used. For example, let's say we're having an article and there's an image that I'm using, but I'm properly referencing where I got the image from, whether it's from a different book or something like that. Am I then covered? I think you've mentioned somewhere that's how you would avoid plagiarism. And the last question, or maybe clarity or just comments, is we play music in our museum exhibitions, like under whatever various themes. So, and it requires us to be registered with, I think it's SAMPRA or SAMPRO. SAMRO, yes. So, however, I did find that such information is not easily accessible or available. And also you mentioned that the use of the purpose of your copyrights use is also quite important to determine, you know, the need to then register or be licensed or whatever. And a lot of times for museums, it's not for resale. So do we still, you know, need to subscribe to this? And is there any other licensing that one is probably missing on and stuff? Thank you.
Thank you so much for that question. Okay, on the 50-year issue, first of all, you'll remember that I did say that on the next to the copyright symbol, you need to place a date. Validity is from the date that you've specified next to your copyright symbol. So the 50 years starts counting from 2023 up until the next 50 years. So even if you die in between, it does not place the work out of copyright. So it from the date that the copyright is specified, the 50 years starts happening. It's not from after the date of or after the passing of the author, because if we use it like that, then we've lost the whole point of creating accessibility to content. Because if I die at 100 and then my work starts enjoying copyright, starts being protected from the date of death, then it creates a further restriction on access to content. So the 50 years applies from the date that you publish and specify the date of publication. I'm not sure if I'm making sense. Okay, and then have I answered your 50-year question?
Yes, you have.
Okay, and then on the issue of museums and the playing of music based on a theme. This is the things that the Copyright Amendment Bill is trying to address, because the current laws are really making it hard for library, archives, and museums to do their job, which is to provide access to information. So the regulations in the amendment bills, it will exempt us from having to always go through these channels of permission and whatnot, because they can take time. To be honest, sometimes you manage to successfully locate a copyright owner, but they don't reply to you on time, but you still have to continue with the project. So the Copyright Amendment Bill is trying to address all of these issues. So until it is officially signed and it is a law that now we don't need to follow these laws of permission, getting permission and whatnot, and paying to play a song or a particular music for a particular event at a museum. Once it's passed into law, we won't need to follow those things as listed in section 19 of the amendment bill. But for now, the safest channels to follow is to maybe find out from SAMRO if you have a particular song that you would like to play, find out from them what channels you need to follow, and then use your own discretion. If they maybe charge you a ridiculous amount of money to play a song, a Hugh Masukela song during a heritage event, then you use your own discretion if you would like to maybe leave or exclude the use of the song, or maybe find something else that is more accessible, something on the public domain, something that is on open access, or maybe even directly go to the source or the creator of the work. If hopefully they don't refer you back to DALRU to say that DALRU administers my copyright, then you can get into an agreement, because those are some of the efforts that we as the university are currently employing to gain access to some of the most inaccessible things, content that is out there. So I'm not sure if that would work for you as a museum, because I'm not sure of the processes that you guys use in terms of what needs to, how quickly you need to access content.
Yeah, I think you've clarified that part. It always depends, I think, but there is definitely a time frame limit to maybe finalizing an exhibition and then ensuring that you have the right music, for example. So it always, as well as, people, some copyrights, people will not respond to you and you want to use a particular image. So you have to just work around all of that. Although you do find archives, and a lot of other material that we use is available there, and you're able to then reference accordingly.
Yes, but you could, for instances where you don't get responses in time, to reference and to specify the copyright owner of the work is always best. And if should they come across your works, you're not distributing, you're not reselling. So should they come across your works that you've exhibited it, you can then follow those channels that you needed to follow before. You could say, okay, we can rectify the issue. Can we have permission? What are your terms now? And you can negotiate. Negotiation is also another best way to ensure that we don't infringe. But also clarify your terms of use and whatnot, and so that they could understand. And also make sure that if you don't have permission from the copyright owner, that just warn your patrons on taking pictures and copying and all of that stuff when you don't have permission on a particular artwork that you're exhibiting. That's what I'd recommend.
Okay, thank you. And the last question?
You said with the music that you play.
No, the last question was citing or referencing an image used, for example, let's say we're having a publication or an article, a research article, and we using a particular image, citing it would suffice as, properly referencing a source without me going to, like, let's say it's an image in a book. So, and it clearly states where it's from and who it's from. And then if you use that for research purposes and you cite it, that would suffice as avoiding plagiarism.
Yes, it would be a way of avoiding plagiarism. But you're using it for research purposes. That means maybe you're going to publish. Are you going to publish and gain? Is there potential?
Yes, publish.
Economic gain. That's where those are the types of things to think about in terms of, do I request permission or not? Because if there's something like potential economic gain, then it might be worth considering requesting permission and getting it in writing and then including it in your work. Because if you were just using it for your own research and you are for an assignment, maybe in such situations, it's meant for your own personal use, for your research. That would be compliant, copyright. And then with plagiarism, with the citing, it also would exempt you from being accused of plagiarism. But where now there's issues of potential economic gain, that's where you start to consider, okay, what risks are there? What can I do to mitigate those risks? So yeah, because right now we do have, for an instance, a researcher will have left the university and they've once published in one of our platforms. Then they would request permission to go and use a figure that they've once used in their research, or then we give or grant the permission in writing to say you are welcome to use this source for this said purpose. So in cases like that, we ourselves at the university do have instances where a person or a researcher externally would request permission from us to use an image or a figure. So I assume that vice versa, you can apply the same steps in ensuring that you don't plagiarize or copyright infringe. This is, of course, in addition to citing.
Yes, I think you clear, definitely. Thank you very much.
Do we have any more questions for Mpumi? Mpumi, then I would just like to thank you so very much for your preparation and this very informative talk. I'm sure all of the attendees did learn a lot from your talk. Thank you so very much. We really appreciate. This then concludes our meeting, and we will inform the members of LISLIG when our next meeting will be. Thank you everyone for attending, and have a nice day.
Thank you.
Thank you. Thank you.
Thank you. Bye.